The day you turned 65, the financial system in this country did not just hand you a Medicare card and a monthly Social Security check. It quietly placed your bank account on a default setting designed to automatically deduct taxes, premiums, and hidden fees before a single dollar ever reaches your hands. Like any responsible parent, Robert goes to a lawyer, pays $500, and writes a legally bulletproof will, leaving that house entirely to his daughter Sarah. He signs it, puts it in a safe, and thinks he has done everything right. Then, Robert passes away. Sarah takes that will to the local bank, assuming she can take over the accounts. The bank says no and freezes everything. She tries to sell the house. A real estate agent tells her she legally cannot list it. A few weeks later, the state sends a letter threatening to put a lien on the front door to recover Robert's old medical bills. And finally, a judge locks that house in a courtroom for 14 miserable months. Robert did exactly what society told him to do. He wrote a will, and it completely ruined his daughter's inheritance. If you are over 65 and your plan for your home and your savings relies entirely on a last will and testament, you need to stop whatever you are doing and listen to me very closely, because you are walking your family into a financial trap that is going to cost them tens of thousands of dollars. My name is David Taylor from Senior Money Brief. For years, I have watched good, hard-working older Americans make the exact same estate planning mistake, purely because nobody ever told them the truth about what a will actually does. Today, I am going to show you why leaving your house in a will is one of the most dangerous financial moves you can make as a senior. I am going to show you the massive tax trap coming in 2027 that makes this even worse. And most importantly, I am going to hand you the exact name of the single piece of paper, a document you can file this week, that transfers your home the exact split second you pass away, completely bypassing the government and the court system. Here is the biggest lie you have been sold about your will. People assume that when you die, your will acts like a magic wand. You leave the house to your son, so your son instantly owns the house. Done. That is not how the law works. A will does not transfer anything automatically. A will is nothing more than a set of instructions written to a judge. And to get a judge to read those instructions, your kids are legally required to go to court. That court process has a name. It is called probate. When you leave your house to your kids in a will, you are not keeping them out of the legal system. You are handing them a mandatory admission ticket to probate court. Think about what that actually means for your family. The moment you pass away, the house does not belong to your kids. It belongs to your estate. And it is completely frozen. Your kids cannot sell it. They cannot rent it out. They cannot even legally empty your checking account to pay for the funeral. Instead, they have to hire an expensive probate attorney. They have to file a lawsuit in county court, essentially, against themselves, just to prove your will is real. And here is where it starts getting incredibly expensive. Probate is not free. Depending on what state you live in, the lawyers in the court system can legally take anywhere from 3 to 7% of the gross value of your estate. Not the equity, the gross value. If your home is worth $400,000, probate could quietly drain $12,000 to $20,000 right out of your family's pocket, just for the privilege of passing a house to your own kids. But the money is only half the nightmare. The other half is the clock. A normal probate process takes anywhere from 9 months to a year and a half. For 14 months, that house sits completely frozen in the legal system. But guess what doesn't freeze? The bills. The county still wants the property tax, and the exact 3 phone calls to make this week. The utility companies still want their monthly checks. And because your bank accounts are locked up in probate, your kids have to pay all of those bills out of their own pockets month after month, while they wait for a judge to finally hand them the keys to a house that was supposed to be theirs from day one. You wrote a will to protect them, but all you really did was hand them a 14-month legal nightmare and a massive bill. And that is just what happens in a normal probate case. But what happens if the state decides you owe them money? That is when the frozen house becomes a massive target. That 14-month waiting period in probate court isn't just frustrating for your kids. It is incredibly dangerous. And here is why. It exposes your home to the single most expensive hidden trap in senior finance, the Medicaid Clawback. Most seniors assume that if they ever need a nursing home or long-term care, Medicare will cover the bill. That is a complete myth. Medicare does not pay for long-term custodial care. Medicaid does. And because nursing homes now cost upwards of $8,000 to $10,000 a month in the United States, a huge percentage of hardworking, middle-class Americans eventually have to rely on Medicaid to help foot that crushing bill. But here is the dark secret that nobody tells you when you sign those facility admission papers. Medicaid is not a free gift. For homeowners over the age of 55, it is essentially a loan. Under federal law, every single state is legally required to operate a Medicaid Estate Recovery program. That means after you pass away, the state is federally mandated to try and claw back every single dollar they spent on your care. If they spent $150,000 keeping you in a nursing facility for 2 years, they want their $150,000 back. And where is the only place a middle-class retiree has that kind of money sitting around? Your house. The exact house you promised to leave to your kids. Now, how does the state actually get their hands on your house? This is where your will completely betrays you. Remember how a will forces your house into probate court? Probate is a completely public legal process. The moment your will is filed at the county courthouse, the state's recovery office gets a notification. They see that your house is sitting right there in your estate. So they walk straight into probate court, file a legal claim, and slap a massive lien on the property. Your kids are suddenly trapped. Before your daughter or son can inherit a single dime from the sale of that house, they are legally forced to pay the state's Medicaid bill. If the medical bill is bigger than the equity in your home, the state takes the entire house. Your kids get absolutely nothing. The wealth you spent 40 working years building is completely wiped out in a matter of months. But here is the legal loophole the wealthy use to protect their real estate, and it is exactly what you need to understand today. In many states, Medicaid can only recover money from assets that go through probate. If your house never enters probate, the state's recovery office often cannot touch it. By using a traditional will, you are voluntarily serving your home on a silver platter to the government. You are practically giving them the keys. Losing your family home to a government clawback is a terrifying thought. But there is a massive federal deadline rushing toward us that makes leaving your house in a messy probate system even more expensive for your kids. And this ticking clock hits right in 2027. The state taking your house is a terrifying thought. But there is a massive federal deadline ticking down right now that makes leaving your house in a will even more dangerous. And it hits right in 2027. Most seniors have absolutely no idea what is about to happen to the tax code. Let me explain. Years ago, a sweeping federal tax law was passed that dramatically increased the exemptions for estate and gift taxes. It effectively created a massive shield, protecting normal middle-class families from paying brutal federal taxes when inheriting a family home. But here is the catch they buried in the fine print. That shield was never permanent. It was written with a strict expiration date. At the end of 2025 and moving into 2026, those massive tax exemptions are legally scheduled to sunset. They will get sliced entirely in half. Now, you might be sitting at your kitchen table thinking, "David, I am not a multimillionaire. I just have a normal house. This tax cliff doesn't apply to me." That is exactly what Washington wants you to think. And it is completely wrong. Because of skyrocketing real estate prices over the last few years, normal middle-class homes are now worth double or triple what they were a decade ago. At the exact same time, the rules around capital gains taxes and something called the step-up in basis, which is the ultimate legal tax protection for your kids, are under heavy political threat. Here is where the 2027 trap springs on your family. If you leave your house in a traditional will, it gets dragged into that 14-month probate court process we just talked about. If your estate is locked in a frozen courtroom right as these 2027 tax changes take effect, your kids could get caught in a massive financial nightmare. A house trapped in a slow probate court during a major tax code shift means your children might be forced to pay crippling capital gains taxes just to legally sell the home you left them. They could be taxed heavily on the artificially inflated value of the real estate, quietly wiping out a huge percentage of the money you worked your whole life to save. The rules of the game are fundamentally changing. If you are relying on a basic will, your estate plan is essentially expiring. The old way of passing down a home is broken, and waiting around to fix it is no longer a safe option for any homeowner over 65. So, if a will drags your kids into probate, invites the state to seize your home for medical bills, and exposes your family to a looming 2027 tax disaster, what are you supposed to do? What is the single piece of paper you must use instead? Here is the exact legal move wealthy families have used for decades to completely bypass the court system. And the best part? It is not some complicated offshore tax scheme. It is a single piece of paper, and in many places, you can file it at your local county office tomorrow morning. There are two tools that do this, and I am going to give you the names of both. The first is called a transfer on death deed. Most people in the legal world just call it a TOD deed. Right now, well over half the states in the country allow you to use one. A TOD deed is exactly what it sounds like. It is a simple legal form. You fill it out, you name your son or daughter as the beneficiary, you get it notarized, and you file it with your local county clerk or recorder's office. Usually the filing fee is around $30. That $30 form replaces the entire probate system. Here is the magic of how it actually works. While you are alive, absolutely nothing changes. You still own your home 100%. You can sell it, you can refinance it, you can take out a home equity loan, or you can even rip up the form and change your mind entirely. Your kids have absolutely no legal right to the house while you are breathing. But the exact split second your heart stops, the TOD deed triggers. By operation of law, the house instantly transfers into your child's name. No lawyers. No 14-month waiting period. No probate court. And remember that terrifying Medicaid clawback we talked about in Chapter 2? Here is where this simple piece of paper shines. In a huge number of states, Medicaid is only allowed to recover money from assets that go through the probate process. Because the TOD deed bypasses probate entirely, your house never enters your estate. When the state's recovery office shows up looking for money, your house simply isn't there. It already belongs to your kids safely. Now, what if you happen to live in a state that does not yet allow a TOD deed? Or what if your family situation is a little more complicated? That brings us to the second tool, the Revocable Living Trust. A trust works like a legal safe. You create the trust, and you put the title of your house inside it. Because it is revocable, you maintain total control. You are the boss of the trust. But when you pass away, the trust doesn't die with you. The trust simply reads your instructions and immediately hands the house to your children. Just like the TOD deed, a trust completely skips probate court. It shields your family from the frozen assets, the massive lawyer fees, and the terrifying exposure to state clawbacks. You are taking back control of your own wealth. You are saving your family tens of thousands of dollars in unnecessary legal bills, and you are protecting them from the looming 2027 tax changes. This is how you protect your family. You do not write a letter to a judge hoping things work out. You use a legal tool that removes the judge from the equation entirely. This sounds so easy, right? But here is where people panic. They hear about the horrors of probate, they want to avoid the court system, and they try to take a kitchen table shortcut that ends up ruining their child's financial life. Instead of using a TOD deed or a trust, they just quietly add their kid's name to the current deed while they are still alive. If you have ever considered doing this, you need to hear what I am about to tell you. Because adding your child to your deed is a massive disaster. It happens every single day. A well-meaning senior sits at the kitchen table, terrified of probate and the government taking their home. They want a quick free fix. So, they drive down to the local county clerk's office and simply add their adult child's name to the deed of the house while they are still alive. It sounds like the perfect loophole. It is actually a financial time bomb. The very second you add your adult child to your deed, they become a legal co-owner of your property. And that means their real-life problems instantly become your problems. If your son gets into a bad car accident and is sued, your house is now legally his asset to be attacked. If your daughter goes through a bitter divorce, her ex-husband can legally go after a chunk of your house. If your child has a business fail, goes bankrupt, or gets behind on IRS taxes, the government can slap a lien directly on your front door. You could literally be forced out of your own home to pay off a debt you had absolutely nothing to do with. You just tied your safe, quiet retirement to their risky, unpredictable life. But the legal exposure is not even the most expensive part of this disaster. The real nightmare is the tax trap. It destroys one of the most powerful wealth-building tools in America, the step-up in basis. Let me explain this in plain English because it is crucial. Say you bought your house for $50,000 decades ago. Today, it is worth $450,000. There is $400,000 of pure profit sitting in that wood and brick. If you pass that house through a transfer on death deed or a trust, the IRS steps up the value. Your kids inherit it at the new $450,000 value. If they sell it the very next day, they pay exactly $0 in capital gains tax. But if you just add their name to your deed while you are still breathing, the IRS considers that a living gift. There is no step-up in basis for gifts. Your child inherits your original $50,000 purchase price. When you eventually pass away and they sell the house, the IRS will fiercely tax them on that entire $400,000 profit. They will lose a massive chunk of the family wealth right to the federal government, simply because you checked the wrong box on a county form. Think about the brutal math there. You tried to save a little money by avoiding a proper estate plan, and you accidentally just handed your child a capital gains tax bill for $60,000 or $70,000. I have sat across the table from grieving children who had to take out a loan just to pay the taxes on a house their parents gave them. It is heartbreaking, and it is completely preventable. Never, ever just add your kid to the deed while you are alive. The legal risk and the tax trap are simply too high. You now know exactly what a traditional will does to your family, and you know the exact kitchen table mistakes to avoid. So, let's talk about action. Here is the exact step-by-step playbook you need to follow to secure your home by tomorrow morning. Let me give you the exact playbook to fix this by tomorrow morning. It is 3 simple steps, and you do not need to be a legal expert to do any of them. Step 1. Find out if your state allows a transfer on death deed. You can do this by picking up the phone and calling your local county clerk or recorder's office. Just ask them directly, do we have a transfer on death deed for real estate in this state? Step 2. If they say yes, ask them how to get the form. Many counties let you download it right off their official website for free. Fill it out at your kitchen table and name your children as the legal beneficiaries. Step 3. Take that piece of paper, get it legally notarized, and march it right back down to the county clerk's office to file it in person. You will pay a small recording fee, usually around $30 or $40, and you are done. Your house is protected. If your state happens to be one of the few that does not allow a TOD deed, your next move is to call a local estate attorney and ask them to set up a revocable living trust. Let me tell you about a widow in Texas named Helen. Helen lived mostly on her monthly Social Security check, but she owned a beautiful home worth $400,000. Instead of paying thousands of dollars for a lawyer to write a traditional will, she downloaded her county's TOD form. She paid a notary $5, paid the county clerk $30, and filed it. When Helen eventually passed away, her son didn't have to hire a probate lawyer. He didn't spend 14 agonizing months trapped in a courtroom. The state couldn't touch the house for medical recovery. The house legally became his the very next morning. A $30 form saved her family nearly $20,000 in legal fees and perfectly shielded the house from the government. You can do exactly what Helen did. I am giving you general education today, not personal legal or tax advice. The rules really do vary by state, so always confirm with your county clerk or a local professional before you file anything. But do not let the fear of doing it perfectly stop you from doing it at all. The 2027 tax changes are coming fast. The probate courts are waiting to freeze your assets. And the state's Medicaid Recovery office is perfectly happy to take your house if you leave the legal door wide open. If this video opened your eyes, do one important thing for me. Send it to one person you know who is over 65. You might be the only person who ever tells them how to actually protect the home they worked their entire life to pay off. Subscribe to the channel, turn on the bell so the next video finds you, and I will see you in the next one. This is about protecting the biggest financial asset you have ever owned. Do not let the fear of doing it perfectly stop you from taking action this week. The 2027 tax changes are rushing toward us. The probate courts are sitting there waiting to freeze your life's work. And the state's Medicaid Recovery office is perfectly happy to take your house if you leave the legal door wide open by relying on a basic will. Before you act, please remember one quick thing. I am giving you general financial education today, not personal legal or tax advice. The exact rules, available forms, and filing fees really do vary by state and county. So always confirm your local rules with your county clerk or a qualified professional before you file your paperwork. But please, make the call. If this video opened your eyes, do one important thing for me right now. Send it to one person you know who is over 65. You might be the only person who ever tells them how to legally protect the home they worked their entire life to pay off. Subscribe to the channel, turn on the bell, and I will see you in the next one.